Okay, we're ready now. Okay, sorry about that. I'm sorry. Okay, Mr. Reid.
My lord, if I could
you want
pick
to
up
continue, please?
If I could pick up where I left off yesterday, we were discussing the idea of remitting matters to the judge below. We've added a couple of authorities to the bundle. The first is Roche and Chief Constable of Greater Manchester Police. That, for your lordship's note, is at 9209. That was a case of malicious, a claim rather of malicious prosecution and false imprisonment against the police. The issue, therefore, was whether the claimant had committed an arrestable offence. And he alleged that there had been, the police alleged that he had committed a deliberate assault or a reckless assault against officers of the police. The judge at trial dealt with the deliberate assault, but failed to deal with the alleged arrestable offence of reckless assault. But in a second judgment, when the matter came back for permission, the judge confirmed that he had found there had been no deliberate and no reckless assault. And then at paragraphs 25 to 27, he deals with the issue, the fact that the Court of Appeal deals with the fact that the judge had given further reasons in his second judgment. And in those circumstances, the court found that it would be, in their words, artificial and wrong in those circumstances to ignore the judge's further reasons and to remit the matter back to the judge. So that is paragraphs 25 to 27 in the Roche case at 9209 now in the bundle. We've also added the White Book, which is now at page 9223, and where it is made clear in the final paragraph of page 1758, final paragraph, that the judge should be given an opportunity to deal with a point. And that point is made by reference to the decision of the Court of Appeal in Greenwich Millennium Village, which your lordships now have in the authorities bundle at 9118. And if I could just take you briefly to paragraph 7 of that judgment, which is at page 9121. And this is Lord Justice Jackson. When asking the judge to grant permission to appeal, Robson produced its draft grounds of appeal and skeleton argument. In his judgment refusing permission, the judge amplified the reasons for his original decision. I have wondered whether it's legitimate to take into account the second judgment. My conclusion is that it's appropriate to take that judgment into account. In English and Emery Reinbold, the Court of Appeal said that at the permission stage, the judge may take or be given the opportunity to provide additional reason for his judgment. In that case, the Court of Appeal was considering the position where the appellant complains about the lack of reasons. In the present case, the notice of appeal complains about lack of reasons in one respect. Furthermore, in other respects, the judge's additional reasons are helpful. I shall therefore refer to the judge's judgment in the permission application, the supplemental judgment, as and when appropriate. And then one sees, for example, paragraph 40 of the judgment, he refers interchangeably to reasons given in the main judgment and in the supplemental judgment. So clearly extensive reference to both the main judgment and the supplemental judgment. And we would seek to distinguish the situation where a judge in refusing permission has amplified or explained his judgment from the situation where it's suggested that the Court of Appeal should require the judge below to give reasons. And that in our submission is a completely different situation. And in the case that the appellants rely on, the court declined to require the judge below to give reasons, not least because the judge had himself refused to amplify his reasons in refusing permission to appeal. Well, that's all I want to say on that issue. I was in the train of our submissions. We were looking at matters that had not been taken into consideration. And I should say that although that's part of our respondent's notice, it's also part of our cross appeal, in that we rely on the additional reasons also in aid of the cross appeal on the fourth ground. Now, one of the things that the judge failed or did not do was to consider any adverse inferences. Now, in circumstances where the issue is in respect of the prime trading is whether it was arm's length and bona fide, and there's an issue too about the destruction of documents in respect of the absconding issues. There is no evidence before the court from Mr. MEHTA insofar as he declined to give evidence or be cross-examined on his witness statement. And there is no evidence from any of the employees of RENISH, and we believe there are at least 40 employees who were all released within 3 days. No evidence for them in respect of the relevant dealing. And we do say that is a case, this is a case, therefore, an adverse inference to be drawn in respect of the commercial relationship between Prime and RENISH. The leading authority to which Milena referred briefly is the Afobe and Royal Mail decision, which your lordships have at 5340. Essentially, the old, rather rules-based approach under Wisniewski, which is A7702, has been replaced by what is described in Afobe as a more common sense approach. But the adverse inference where witnesses are not called or do not give evidence is a key part of common law procedure. And indeed, the DIFC court itself has confirmed that in two decisions. Firstly, the Mazoon and Naqvi decision, which your lordships have at 3915, paragraph 56, and the IGPL and SCB, Standard Chartered Bank decision of the Court of Appeal, which you have at 3819. Curiously, there is no particular reluctance on the part of RENISH employees to provide it. When one looks at, for example, Mr. Anshul Gupta, who was the RENISH logistics manager, if I can take you to page 2436. Oh, yeah, sorry. Sorry, that's a misreference. But just let me, sorry, if I could take you to 3379. This is Mr. Gupta responding to an email from Mr. Sada. And if I could take you halfway down to the paragraph beginning, and to make the above channel more streamlined, RENISH main departments, MD, Finance, Shipping, and Ops, are directly linked with you to communicate. So he's describing the links with Prime. Although it was physically not there, but a deemed offer of yours seemed inside the RENISH office. Even you have allotted a few email ID open access spaces for communication and ease of flow of documents to carry out your business operations need as mentioned above. And then in relation to your specific inquiries, was the RP Shipping, that's a Prime email account, email address only under your control, or more range of people in RENISH office had access to it? And Mr. Gupta, the logistics manager of RENISH, replies, in routine, I was using it, but it was PW shared in a WhatsApp group, so many persons may have access to it. So a number of RENISH employees had access to the Prime, the RP operations Prime email address and email account. And it's clear that Mr. Gupta was using that account. If one goes to, for example, to 8913, one sees here Mr. Gupta, who's the logistics manager at RENISH, signing off an email as the Prime, as a shipping and chartering manager at Prime. So a RENISH employee using a Prime email is describing himself as a Prime employee. And indeed, the email that he was the email address that he described, the RP Prime email address, if one goes to 3335, this is the RENISH, sorry, the Prime contract that was intended provided to the bank. In the alleged sham contract, notices are to be given by RENISH to Prime at the RP Shipping Prime Energy email address. So Prime is purporting to contract with RENISH on the basis that RENISH will provide notices to an email address which is actually controlled by a RENISH employee. So RENISH would be giving notice to one of its own employees under that provisions of the, we would say, sham contract. And so we say that's directly relevant to A's case that RENISH and MEHTA were operating at arm's length, and to, sorry, that the appellant's case, and to SBM's case that that contract was a sham. Now, the judge, as you'll be aware, excluded evidence of the close relationship between RENISH and Prime, and the absence of correlation between the payments and any shipments of oil. But he conceded that that was, in his words, potentially important evidence if accepted. The reason he excluded much of that evidence was by reference to principles of pleading. And so he says essentially all points, for example, the point I've raised about the fact that the contract gave as a Prime email address, an email address that was being controlled by Mr. Gupta, who was a RENISH employee. But it is clear in our submission that pleadings are intended to be a concise summary. And indeed, the commercial court guide on which the DIC court rules rely to some extent makes clear that the default page limit for a pleading should be 25 pages. And indeed, the DIC court in Dea and Tallinn, as made clear in the Dubai DIC court practice at 17.17.5, makes clear that pleading should mark out the parameters and the general nature of the case. And we say that insofar as it is clearly pleaded that these two entities were not trading at arm's length, and that they were involved in presenting sham invoices and sham contracts, if you ask the question of whether the defendants were able to prepare to deal with the case against it, of course they could. All they needed to do was to make the case that they were separate companies, that they were trading at arm's length, to explain the transactions and to provide evidence that they were, as I say, entirely separate trading entities.
Mr. Reid, can I interrupt you here? Can you assist us by referring to the pleadings, the actual pleading? What did you say in that pleading?
Certainly, my lord. Yes, if one goes to the payment representative.
What is the page on the pleading?
Yeah, my lord, I have limited time, but if this is how you're
just go ahead. Don't worry. We'll give extra time to Mr. Pillay if he needs.
Okay. Well,
otherwise I'll be struggling to open the pages myself. It's not okay. Hard copy you can flick here. I will do. Yeah. I'm not very good at this. Can you just give me the page for your pleadings?
Yes, the pleading for the particulars of claim is at 601, my lord.
601. Okay.
Yep.
And can you read in 601 what part of your pleadings refer to this point, the one that you just submitted?
Yes, my lord. Well, the payment representations are at paragraph 12.
Was it 601 or 610?
601.
601. Okay, sorry. 601.
The payment representations are at paragraph 12, my lord.
Paragraph 12.
The fraud of the representations is at paragraph 40. Paragraph 40. So Prime and RENISH and the contracts and the invoices were shams. There was no intention of full performance or repaying payments 4, 5, and 6, and there was a conspiracy with intention to deceive and defraud SBM. And then your lordships also will have read paragraphs 42 to 61, dealing with the other facts and matters. So there were obvious lies in stalling the repayment of the fourth payment. That's paragraph 49. Absconding is dealt with in paragraph 50. There's a failure to respond to the worldwide freezing order for 2 years. That's paragraphs 51, 52. And there's a dissipation of payments, including back to RENISH and related parties, is paragraph 59. And then in terms of the, and also in terms of those dissipations, they're speedy, they're round figure sums, and they effectively empty the relevant NBK accounts. The bank's accounts are set up to speed to facilitate speedy transfers without scrutiny. That's an important paragraph, my lord. That's at paragraph 61 of the particulars of claim.
Paragraph 61, yeah, okay.
My lord, yes. Does your lordship have that?
Yeah.
I'm grateful. So the core factual allegations were neither probed nor denied by the appellants, and indeed the dissipations as described in the paragraph 58 table, which your lordship will recall, are admitted, and that's the defence paragraph 25.
What page is that?
Sorry, page 20. That is page 682. We can go to the defence now if that would assist. 682.
Okay.
Yes.
Okay. Take note of that. Okay.
But if we take it in stages in terms of the defence, it starts at page 677.
Okay.
And does your lordship see at paragraph 14? Page 679.
I'm just taking notes of the stages. I'll look at them later.
Okay. Second sentence of paragraph.
I mean, it's not possible for me to the way you are citing, and by the time I press and touch it and waiting for the page to appear.
Yes. Well, I'm sorry, we're all suffering from the technology. I've happily had it in paper, so I'm slightly.
I have to look at them later. Okay.
So paragraph 14, all of the oil trades were genuine, for which Renish requested finance from the bank were genuine. So that's the joinder of issue as to whether these are bona fide trades or genuine trades between Prime and Renish. And then if we go on to paragraph 20, we see there the consignments, reference to the consignments of oil, 1, 2, and 1, and subparagraphs 1 and 2. And you'll see, for example, in paragraph 1, second sentence, this was placed Renish in difficulty as the bank had already advanced to Prime in anticipation of delivery, so an intimation, therefore, of payment in advance. And then in terms of the onward transfers at paragraph 26 of the Renish and Mr. Mehta's defence, further with regard to the paragraph 58 table, and then jumping on to little subparagraph 3, nor was there any connection, direct or indirect, between the companies and Renish. So a denial that Renish has anything to do with the recipients of the funds, save only that PetroHub was owned by Mr. Ayaz, a factor which is of no relevance. So essentially a denial of any connection, even with PetroHub, notwithstanding the fact that Mr. Ayaz, the CEO of Renish, is the owner of PetroHub. And then critically, over page subparagraph 4, none of the disbursements, save only for one of $7 million, was to or for the benefit of Renish, and these were strictly transfers in the ordinary course of business. And of course, that's what the judge particularly picks up, the failure to explain what course of business. And now, for example, the extent you've got monies paid to Noven and Acton, these entities in India and Singapore, the easiest thing would have been for Mr. Mehta or Renish to explain what the transactions were, why these large sums of money were being paid to companies that had nothing to do with oil trading in Singapore and India. And that's the failure to provide that explanation. And then 5, none of the payments was for the personal benefit of Mr. Mehta. Well, Mr. Mehta, as we said, is the sole shareholder of Renish. So strictly speaking, as a matter of law, it might be true, but it is straining credibility to suggest that he had no interest or motive by reason of having no benefit in any of the payments out of the account. So that is in essence the joinder of the issues in respect of bona fides and arm's length between those companies and the destination, the ultimate destination of the transfers. And we say that the evidence before the court was within the parameters of those pleadings. Now, let's look very briefly, if we may, at some of that further evidence. If we can start with the Prime accounts themselves. So these are the accounts with MBK. And these were opened, if we look at 1442, so pursuant to the order of Justice Ali Al-Madani, DLA Piper, who was then acting for NBK, provided disclosure. And if we start with 1442, this is a letter giving information in respect from MBK in respect of the accounts. And when one looks halfway down the page at A, the prime accounts with MBK were opened on the 16th of February 2017, which was when the facility was being negotiated. The current authorized signatories of the prime accounts are Mr. Farhang, now he's the owner of Prime, but also Syed Adil Naqvi. That possibly raises the question, well, who is Mr. Naqvi? Well, Mr. Naqvi is an employee of RENISH, and we see that from 1472. And the top of that page, paragraph 57.5, and sorry, this was the misreference I gave you earlier, 5 lines into that paragraph. Some of our sponsored employees, this is Mr. Mehta's evidence, from abroad, like Mr. Adil Naqvi.
Sorry, give me the page again. Give me the page again.
1472, my lord. 1472. So this is Mr. Mehta giving evidence that both Mr. Naqvi and Mr. Gupta, the logistics manager, were RENISH employees. And when we then look at 2852, this is Mr. Naqvi's UAE residence card. And you see that his employer is said to be RENISH PETROCHEM.
Okay.
And if I could just briefly take you over page to 2853, you have his resident identity card again, a UAE identity card again for Mr. Naqvi. And if you look at the back of that card, you see his signature. He signs as Adil. And you see his Adil signature there.
Okay, you are saying that the same employee of RENISH is also signing for Prime. That's what you're saying.
Yes, and critically, what he's signing are the payment requests to the bank. So we've seen that he's a signatory of the bank accounts for Prime. And he's also all of the critical. So if you look at the 5th payment, that's the payment made on the 22nd of May 2018. It's Mr. Naqvi who's making the Prime payment requests to MBK. And so by way of example, if we just look at 3532.
And you want us to infer from that there was this plan to defraud?
I would infer from that they are not two companies operating at arm's length, and that the trading relations between them are not bona fide.
Okay.
And if I could take you to 35, I'm sorry if I'm being slow, but it's pretty clear when one looks at the evidence what the true situation is. So, for example, this 3532 is a request for of the monies paid in on the 22nd. So we're the day after the 5th payment. We're now on the 23rd. Mr. Adil Naqvi is signing a Prime payment request for NBK to send 1.5 round figure US dollars to the beneficiary being RENISH. So again, in trade finance terms, makes absolutely no sense for the trade finance to be immediately paid out to the trader and not to the supplier. And
payment to be made to the trader. Payment to be made to the trader.
Yes, so the monies are being paid back by the supplier to the trader. And if one goes back to 3530, same day, another payment, also round figure, $5.6 million from the Prime account to RENISH, being signed off by Mr. Naqvi on behalf of Prime, but we know that Mr. Naqvi is in fact a RENISH employee. So having established that, let's look at two of the primary recipients. When we start with Petromaster, Petromaster received, now that's the prime related party. Petromaster received 12 million US dollars. And we can see that from the fund flow diagrams, which I've already taken you to. But in terms of the evidence from NBK, if we could look at 1443. So this is a letter from DLA Piper on behalf of NBK explaining that we are instructed by our client that Petromaster held accounts with our client. And then if one goes over page to 1444, in terms of Petromaster, we see that the 16th of February 2017, so again around the time of the facility agreement, Mr. Farhang of Prime opens the account. And if one looks to the following box 3B, Petromaster, the names of the current signatories are said to be Mr. Farhang and Mr. Shoaib Mohammed Patel of Indian nationality. He's the signatory. And that begs the question, well, who is Mr. Shoaib Patel? Well, if we look at the documents at 2534, we see an email heading, and the CC list includes as its last member, Mr. Shoaib Patel of RENISH PETROCHEM. And that's because Mr. Patel is another RENISH employee. And if we go to page 2787,
are these all in your submission, Mr. Reid?
Yes.
Are these all in your submissions?
Well, my lord, yes, we deal with the employees, common employees.
Those detailed points that you're raising just now, are they in your? I mean, just to save time, you don't have to go item by item. But
I think I hope it will be helpful.
But what is in my mind now, Mr. Reid, is those issues, factual, detailed issues that were raised by you in the last today and at the end yesterday, were not by the judge, were not mentioned by the judge in his judgment. What is the effect of that? I know you tried to say that the judge doesn't have to strike the T's and the dots and things like that, you're saying, but those issues that you raise are, to me, very pertinent. But the fact that they were not raised by the judge in his judgment,
well, the judge,
is the effect? Are we supposed to go through the trial as a trial judge again and make our own conclusion? Or because we are merely to review, the word used is review the judgment. And
my lord, you are to review. The judge disregarded this evidence because he believed that these facts were not pleaded with sufficient particularity. Yes. We are saying that in your review, you should find that was wrong. That this is highly important evidence, which is within the general parameters of the case as pleaded, and you're therefore able to consider this evidence.
Now, you rely upon these materials in support both of your cross appeal and the respondent's notice, as I understand. Is that right?
That is right.
Yeah. Okay.
Well, look, I hope this won't take up much further time. We're getting through it quickly. If I could just get into a counter.
You may stumble. Can you just give us a paragraph number reference in your consolidated submissions, because I know so I know where you are. You're dealing with the section with the excluded evidence.
Around the 70s, the 70s, my lord.
Okay, thank you.
So we were asking who Mr. Shoaib Patel was. We've established that he's a RENISH employee. And then at 2787, we see this is a PetroMaster document that he's signed. So this is signed by Shwe Patel. He gives us his telephone number at the bottom of the page in the footer, a number ending 2992. This, as we understand, is in fact Mr. Sudder's telephone number. And one sees that if one goes back 7 pages to 2780.
Yeah. Would you mind very much just pointing me to the particular paragraph where this is referred to, rather than just telling me it's the 70s? I know that.
81, my lord, I'm told.
Thank you. And when
So
it comes to drafting a judgment, the most useful guide is the skeletal outline rather than wandering through the morass of transcript, although one does also refer to transcript. Thank you.
Of course. So, my lord, 2780, we see a prime document signed by Mr. Naqvi, who's the Renish employee. But in the footer at the bottom, you see Mr. Sudder's email, Mr. Sudder being the prime consultant, and then the same phone number ending 2992 that was given by Mr. Shwe Patel, another Renish employee, then acting on behalf of PetroMaster. Now, we say that in these circumstances, it's clear that both Prime and the PetroMaster accounts are being operated by Renish employees. And it's SVM's pleaded case in respect that the bank accounts were set up to facilitate the transfer of funds. It's SVM's pleaded case that the commercial arrangement was shams. It's the appellant's pleaded case that Prime and Renish were in a commercial relationship at arm's length, and that payments out of the Prime account had nothing to do with Renish. Well, how can they say it's got nothing to do with Renish when the payments are being instructed by Renish employees, when the payments are made to recipients such as PetroMaster, which are similarly being operated by Renish employees? And a similar pattern occurs when you look at PetroHub. The accountants agreed that PetroHub was a related party in accounting terms of Renish. PetroHub received some $14 million US. It's owned by Mr. Ayaz, who's the CEO of Renish. And indeed, it's making payments to Mr. Sudder. And one sees that, for example, at 3416.
This is paragraph 75 of our skeleton.
Sorry, this is in paragraph 75 of our skeleton. Sorry.
Thank you.
So it's 3416. So this is PetroHub making payments to Mr. Sudder. And of course, PetroHub is essentially a related party of Renish. And for the accountant's agreement, for your lordship's notes, that's at page 1895. Again, we say obviously relevant to the appellant's case that these are two commercial parties at arm's length having genuine commercial dealings. And it's obviously important to the suggestion that payments out of the Prime account had nothing to do with Renish. And also the pleaded allegation that the ownership by Mr. Ayaz was irrelevant.
Now, I'm sorry, just again, it goes to the utility of the skeleton. I'm looking at paragraph 75 to which you referred me, and I don't see a reference there to 3416. Is that, have I overlooked something, or I just want to make sure that what you're referring to me now is not missed here.
Okay. Yes,
I'll make a note of it on the skeleton.
Okay. Well, yes, there may be particular documents additional documents to which we refer.
It might be helpful if you could subsequently give us a bit of paper with any references, cross-reference to the paragraphs
yes.
in which you rely upon those things.
My lord, yes. My lord, yes. The other exercise which we undertook was my manuscript notes from the hearing, the trial in front of Lord Justice Glennie, obviously refer to the trial bundle references, and those instructing me have put in the appeal bundle references, which show all of the documents I referred to in the appeal bundle. That may also be of assistance.
Okay, thank you.
So we've looked at PetroMaster, we've looked at PetroHub. If we could look very briefly at Astron and Noven, and you'll recall that of the sixth payment, 1.7 million ends up with Noven, which is a Singaporean textile company. $5 million ends up with Astron, which is an Indian company trading in granite headstones. You have that at 1721 in terms of their commercial activity. Both companies are clearly identified in the paragraph 58 table as recipients of these round figure numbers. Mr. Sada's evidence was that both companies were RENISH subsidiaries, and the reference for that is 1318. No attempt has been made by the appellants at any point to explain the ownership of those companies or what these payments could possibly be in ordinary commercial terms. And we say again that's relevant to the appellant's case that they were involved in genuine trading at arm's length, and to the appellant's case that payments were made out of the prime account had nothing to do with RENISH. Interesting, just two further points in respect of the actions of the prime employees in operating RENISH. RENISH staff were involved, for example, in producing the documents provided to the bank, including the certificate of origin. If we could just turn to 3359. And then if it is an email chain, so if you just briefly work up the chain, so this is all the 21st of May. So Vanisha Bansal, who is a RENISH employee, she writes to Mr. Malik, who's an SBM employee, saying the COO, the certificate of origin, will produce once the goods are ready. And then Mr. Malik, the email up the chain says, thanks, Vanisha, please ensure the COO is with us prior to disbursement. This is in relation, I should say, to the fifth payment being disbursed. And then the email at the top of that page, 3359, Miss Bansal says the certificate of origin price can be arranged on beneficiary's letterhead, beneficiary's prime. So she's saying, well, I can give you that on prime's letterhead. Please confirm to arrange accordingly. And then Mr. Malik, at the bottom of page 3358, continuing up the chain, is confused by that. Wouldn't the certificate of origin be from the supplier? So on the supplier's letterhead. And then Ms. Bansal responds, the email at the top of that page, same day, 21st of May, please find attached for your reference. Thanks. And then if one goes to page 3353, one has the prime letterhead certificate of origin presumptively produced by Ms. Bansal. This is to certify that the total quantity of 33 kilotons of fuel oil to be supplied to RENISH is of UAE origin. And leaving aside the question of whether it could possibly be of UAE origin, or whether there's any truth in that assertion.
Mr. Reid, I'm going to interrupt you again here.
Yes.
Prime did some form of settlement with SBM.
My lord, yes.
Prime could have been a good witness to explain exactly what the relationship it has with RENISH. But you did not call Prime. Of course, the respondent, I don't know why they'll explain why they don't call Prime. But you know, you're putting your argument, making what you call accusation between Prime and RENISH, and yet the bank has settled with Prime. Can't we infer from there that the bank has already satisfied that everything is all in order?
No, my lord, you can't.
Because
they're not a compellable witness. They're out of the jurisdiction. And we had been obviously involved in years of hostile litigation with them. They settled. They wished to have no further part in these proceedings.
Yeah, but what about the bank? The bank was the one who dealt with them. They settled, they shook hands and settled with them. And now the bank is going after Prime's partner, so to speak. That is giving me some problem. I'm just expressing to you what is in my mind. That's all.
Well, that's helpful. That's helpful, my lord. In terms of other sham documents, there's only one other set of emails that I wish to take you to. You'll recall that in mid-June 2018, RENISH was seeking an extension of time for repayment of the fourth payment. So if I could take you to page 3366. This is an email, again drafted by Felicia, who's a RENISH employee, which she sends to the RENISH-operated Prime accounts. And it appears to be a draft of an email explaining that purporting to be from Prime, explaining that the oil from its end supplier is not meeting our agreed specifications and seeking an extension of 1 week of time. If one then goes to 3374, one sees Mr. Gupta purporting to be acting for Prime as its shipping and chartering manager, sending that email to RENISH. So it purports to be Prime to RENISH saying we've got a problem with quality. But in reality, it's RENISH to RENISH because Mr. Gupta is a RENISH employee and he's sending it to RENISH. That email is then sent by, purported to be sent by Sandeep of RENISH to Prime. So he sends a reply, what purports to be a reply, ref to subject, please be noted that we're in tremendous pressure from our client, that's say Lanka. They're chasing us badly. And then this mock email, this sham email exchange between Prime and RENISH, but in fact just between RENISH employees, is then shown by Ms. Bansal, or it is sent by Ms. Bansal to SBM. So she says to Mr. Malik, please note our team, please refer below email from operations. Please note our team is continuously chasing the supplier. And then the following sentence, we still maintain our request for 1 month's extension. And of course, the balloon is going to go up when the fourth payment is not repaid. So delaying the fourth payment is critical in terms of allowing dissipation, allowing RENISH to be dismantled and all of the staff to be released and the office to be closed, etc. And then page 3372, following the chain up, we have an email from Mr.
This is paragraph 82, is that right? Just looking at RENISH sent 3 emails on 18 June 2018, etc. I'm sorry, I may have the wrong one. I'm just trying to track down the paragraph number.
Yes. And so Mr. Malik then writes back saying that we cannot extend the payment date. And you will note that we paid your supplier on the 24th of April. So that's the reference to the payment having been made, the fourth payment having been made to Prime. And then Ms. Bansal goes back on the 19th of June. Apologies, says, keep you informed in advance if such irregularities happen in future. However, this is a very genuine problem which is beyond our control. Now, there's no corroborative evidence in respect of this alleged quality issue. It appears to be presented to the bank in an exchange of emails between Prime and RENISH, which is in fact an exchange of emails between RENISH and RENISH employees in a form that has been drafted apparently by Ms. Bansal, again, of RENISH. Now, again, whilst the judge declined to consider that evidence, we say it's relevant to the alleged bona fide commercial trading at arm's length between RENISH and MEHTA, and it's directly relevant to the bank's allegation that the Prime contracts were shams. So the Specific exclusions by the judge were exclusions of evidence that Renish and Prime operated as a single entity. And Renish obviously pleads that its orders were genuine in good faith. Renish pleads there was no connection with the recipients, and Renish pleads that the onward payments were in the ordinary course of business and no benefit to Mr. Mehta. We say the evidence that we've just looked at, even very briefly, flies in the face and entirely undermines those pleaded assertions. The judge also excluded the evidence of the setting up of the NBK accounts. And we've seen that both the Prime accounts and the PetroMaster accounts were opened on the 16th of February. In the case of the primary accounts with Mr. Naqvi, a Renish employee as signatory. In the case of the PetroMaster accounts with Mr. Patel, also a Renish employee as signatory. And we've seen that it's Mr. Naqvi who instructs payments out of the NBK Prime accounts. So, and that evidence is disregarded by the judge, notwithstanding that at paragraph 61 of the particulars of claim, the bank specifically pleads that all accounts at NBK to facilitate transfers were intended to, in the words of the pleading, enable funds to be dissipated as quickly as possible in furtherance of fraud. So the circumstances of the setting up of the accounts and the reason why all of the accounts were set up in one bank was to facilitate rapid transfers of funds in furtherance of the fraud. So the judge in our submission was wrong in thinking that the issue had not been pleaded. That issue specifically with some particularity in paragraph 61 of the particulars of claim. The judge also excluded evidence that there had been no purchase or sale of oil. His reasons in doing so seem a little confused in that he appears to reason that exclusion on the basis that there is no allegation of forgery. There's no pleading as to the mismatch between payments sought and the cargoes of oil. But Renish's case, as we said, was that the trading was genuine. SBM's case was the trading was a sham. So clearly the presence or absence of any oil sales or transfers in respect of the 4th to 6th payments was directly relevant. And indeed, the experts had agreed, page 1896, that the 1st to 6th payments were not linked to cargoes and were not. And so it was directly an issue whether there had been actual and genuine trading. And it's the bank's case that this was part of a single fraudulent scheme. And insofar as the 1st to 3rd payments were repaid, which was entirely accepted, we would submit that that was in order to ensure, as is made clear in the master table, that at the time the balloon went up, they had maxed out in terms of the maximum outstanding under the facility. And I do want to just give you quickly the references in respect of the original attempts. If one looks at 2915, one sees an email dated the 10th of May. So this is during the negotiation of the facility agreement. And Mr. Jimangol of SBM writes to Mr. Ayaz of Renish. And then if one goes to 2915, 3rd paragraph, in one of the previous emails, you requested the following structures, and he copies and pastes some text in red. And you'll see the total, so the penultimate line of that section in red is US $50 million. So that was the facility originally. So very keen to push up the maximum amount of the borrowing. And if one goes to 2967, one sees the minutes of the SBM Board Credit Committee held on the 18th of October. And you see the conclusions from that, the 2nd bullet point. At all times, the total exposure for the client would remain within the limits of $30 million. So they are expressly restricting the facility to a limit of $30 million. And then the last document on this at 3337. This is an email for the 18th of April. So just before the fourth payment. So we would say, as we're going into the stage at which these payments are made, which are never going to be repaid, we have on the 18th of April an email from Mr. Ayaz, copied to Ms. Bansal, but to the bank, to SBM, including Mr. Malik. And then the first, from paragraph 1, we've sent a request for an increase of credit limit by $20 million US dollars. So they want to again push it to $50 million. And the explanation is in paragraph 4. We've been supplying to LEOC under the tender. Normally, under one tender contract, there are multiple parcels. Hence, LEOC want to assign whole contracts in one go instead of providing assignment for each parcel. Accordingly, it's requested to accept single assignment for the whole contract value. Well, that purported explanation makes little or no sense. And again, there's absolutely no corroboration that Lanka were pushing for larger, to be supplied larger quantities, which would require larger payments. And indeed, there is no evidence to support that assertion being made allegedly as part of genuine commercial dealing in this letter, in this email. So we say there is ample evidence that the trading was not bona fide arm's length. And indeed that the appellant's pleading of legitimate trading of transfers in the ordinary course of business, the appellant's pleading that they had no knowledge or connection with the transferees, and that the transfers were nothing to do with RENISH, all of that pleading is fatally undermined by the evidence that this court should, in our submission, take into account. And that's all we want to say in respect of the additional reasons in terms of upholding, buttressing the decision by the judge in respect of the fifth and sixth payments. Moving to our, if I may, to our cross appeal in respect of the fourth payment. We would start by repeating the point that the judge did not find that 4 of the 6, or indeed the fourth payment, were non-fraudulent. There's no claim by the appellants for a negative declaration. The judge's PTA judgment at page 1057, paragraph 16, he spells out that it's an important difference. And then in his words, I didn't find the fourth payment not to be fraudulent. I simply declined on the evidence to infer that it was fraudulent. Now, we say, my lord, that is a single inference. It is in effect an evaluative error in one paragraph, paragraph 55 of the judgment. In terms of the test for the review of an inference or an evaluative error, the test is, as set out in AR against the Chief Justice of Greater Manchester, whether there's been a flaw in the reasoning or an inconsistency, a failure to take account of a material factor, or the evaluation is, or the exercise discretion is obviously wrong. So again, we're into Wednesbury reasonableness, or grounds that feel like Wednesbury reasonableness. And we would say that obviously this is one where it is obviously inconsistent. What he finds in respect of the fourth payment is obviously, in our submission, inconsistent. Now, in terms of whether this court, what this court can do by way of review, we say the trial judge is not in any privileged position, because the trial judge was simply making an evaluation and exercising, drawing an inference by reference to the documents that were before him. And I should say, in terms of the test, the test was essentially confirmed in the DIFC Court of Appeal in the Amira Foods decision, which your lordships have at 3686, paragraph 36. Again, did the court take into account immaterial factors? Was an error of principle, or was the decision of the inference obviously wrong?
I'm not sure that the drawing of an inference of fact from primary facts is actually properly characterized as evaluative. Evaluative findings might go to issues of, say, reasonableness, good faith, all those sorts of
yes, mixed law and facts, where you
whatever, yeah. But
abuse of process.
and we can I think the High Court in Australia and the Singapore Court of Appeal have drawn the analogy between evaluation and discretion for the purposes of review. So you can take a similar approach. But if I'm looking at primary facts and I'm looking at the question whether a second order fact or some other fact can be inferred from those primary facts, I'm not quite in that same territory for the purposes of review, am I?
Well, in terms of the high standard of review of an inference, we would say that you are, and therefore, if the inference is plainly wrong, or if the reasoning of the inference is inconsistent.
Well, it's a review of the factual finding that we're talking about here, isn't it? You're asking the court to you're asking the court to find that the judge on the materials before him was bound to find, as it were, that there was fraud in relation to as pleaded, in relation to the fourth payment.
My Lord, yes, I intend to live with that.
Yeah, okay.
So we do say, and we say, if one looks, I mean, our core point on inconsistency, and obviously wrong, is that there is no difference between the fifth and sixth and the fourth payments. And to some extent, that's a symmetry point with my learned friends' submissions. If one looks at the fifth and the fifth payment, 23rd of May, the monies had been paid out by the 28th, so within 5 days. Sixth payment within 6 days, and we've looked at the funding diagrams in the expert evidence, and the fourth payment was paid out within 7 days. So in each of those cases, each of the fifth, the sixth, and the fourth, the monies were paid out within a week. So in terms of rapidity of dissipation, there is no material distinction. And the judge was therefore wrong, plainly wrong, to find that there was no similar link in terms of the timing to justify the inference. And similarly, when one looks at the entities to which funds were transferred, in all cases, the funds were transferred to entities involved with RENISH. So the fifth payment was transferred to PetroHub and RENISH, PetroHub being a RENISH-related party. The sixth payment was paid to Noven and Astron, said by Mr. Sutter to be two RENISH subsidiaries and RENISH. And the fourth payment was paid only to RENISH. So again, there is no material distinction in terms of the recipients of the dissipated funds. And then thirdly, as to the lack of any commercial reason, that point applies with equal force to all of the fourth to sixth payments. There is no explanation offered or provided only for the fourth payment, which could distinguish that from the fifth to the sixth. In terms of post-fraud conduct, the absconding, etc., and the contempt of court, that applies with equal force to all of the fourth to sixth payments because it followed precisely from the sequence of those fourth to sixth payments. So these are findings that simply cannot be reconciled, and that therefore the appellate's intervention is justified. That legal proposition is made good in LA Micro Group, which your lordships have at 5966. And that's paragraph 73, 75 of that judgment. The court does, in paragraph 55, purport to attempts a distinction. But that is a distinction that has not been made by any party in any pleading, or indeed at all by anyone during the course of the trial. And what is said by the judge in paragraph 55 is that the fourth payment, in his words, was not due to be repaid until mid-June 2018. Now, just pausing there, the implication of that is it wasn't going to be repaid until much later. So the very language the judge uses is redolent of a suggestion that he's seeking to distinguish the fourth payment from earlier payments, because he's saying, no, the fourth payment was later, it's to be repaid later. So there's a confusion even in the words used. the judge may have thought that there was some switch in terms of fraud in Mr. Mehta's mind, and that switch had been provided by the malicious email and the alleged collapse of the company pursuant to that malicious email. But that email was sent on the 9th of July, and all of the 5th and 6th and 4th payments were made well before the 9th of July. So the 5th and 6th were made in May and June, and the 4th payment had been made in April 2018. So on any basis, we simply do not understand the distinction the judge seeks to draw in paragraph 55. At no earlier point in this case has there been any distinction made between the 4th and the 5th and the 6th payments. So when Justice Ali gave summary judgment on the 27th of September 2020, he had no hesitation in finding conspiracy to defraud for the full $31 million. And when Justice Glennie set aside that summary judgment in respect of fraud, again, he didn't seek to make any distinction between the 4th and the 5th and the 6th judgment. All he suggested was that the fraud claim needed disclosure and the cross-examination of witnesses. So there's no earlier distinction between the relevant payments. And indeed, when the matter goes back before the judge in his PTA judgment, he makes no further, in contrast to the other points and grounds of appeal, where he explains and clarifies his reasoning to some extent. On this ground, he makes no attempt to explain further. It may be said that he comments perhaps wistfully that in his words, it may be that a finding of fraud could also have been made regarding the 4th advance. He refers back to paragraph 55, but makes no attempt to expand on or clarify his reasons. And we say that's precisely because there are no reasons that the 4th can be distinguished from the 5th and the 6th. And that brings me lastly to the costs appeal. Now, your lordships will have seen that the judge's order is that SBM recover only half its costs of the action on the standard basis. And as I intimated at the beginning of this hearing, obviously any cross appeal on costs may feel like a bit of a damp squib, but the costs of the action are very significant and likely to be just short of $2 million US. So the fine imposed essentially or the discount imposed by the learned judge was of an order of around $1 million US. In terms of his grounds for that were essentially that the evidence went beyond SBM's pleaded case. And we've explored that issue by reference to the pleadings. We say that the evidence was within pleadings which are designed to sketch the parameters of the case to allow the defendant to know the case that's being made against them. But in any event, we say that if the judge had considered evidence irrelevant at trial, he of course could have controlled the evidence with his case management powers, and those are expressly given for that purpose in RDC 29.9.
But except that if you get up on the 4th payment, the question of costs at trial will be open for resubmission by both parties.
Yes, my lord, absolutely.
Yep.
The
cross appeal would be moot from that point of view. It's only if you fail.
My lord, yes, and the references for that in England would be CPR 5220. Which provides that in relation to an appeal, the appeal court has all the powers of the lower court, and then some.
Yeah, I think we have that here too.
Yes, exactly, and the appeal court has power to make a costs order. That's in your lordship's reference, lordship's note. That's RDC 44.108. On hearing appeal, the Court of Appeal may, and then the orders the court may make. So we entirely accept that. Just going back to the judge's grounds for discounting the costs. First, I should just say, in terms of the evidence, the SBM's oral submissions by reference to that evidence only took 2 days, and indeed was largely a reformulation of the oral opening that had already been planned for the wider trial against all of the original defendants. The second
this is
round,
actually this is really the tail at the end of the dog, isn't it? I mean, we've got fairly detailed submissions from you.
Yes.
Maybe you could just give us the killer points, which I think is procedural fairness, isn't it?
I'll proceed from the canter to the gallop. In terms of the volume of material in the trial bundles, we say much of that was the evidence required by Prime. In terms of the bundle index, there's obviously shared responsibility of both parties in respect of what goes in and what should not go in. And we say that a 50% discount of about $1 million is entirely disproportionate. We say on the cost decision, clearly it's an exercise of discretion and therefore similar grounds to inference. In other words, there has to be well, as set out in Melody and Mellance, there has to be a departure from due and proper process or an error of principle. We say in this case there are in fact both, because there was the procedural irregularity which your lordship has in terms of, and your lordship really needs to look on that at the discussion in day 3 at page 2472 in the transcript. And essentially we were asked whether SBM would be seeking its costs if successful, and we explained that we would be seeking costs, and we would seek costs on the indemnity basis. We were asked whether we make that application now, and we confirmed that we were, but that application, we say, was an application for our costs on a successful event and our costs on the indemnity basis.
I think you made that point to us earlier on, actually.
I did, and the partial success had not been considered. We say too that the decision was perverse in that, well, firstly, we say that the suggestion that we lost most of the issues, we succeeded on the majority of the claim, that's the 21 million. We succeeded on the 5th and the 6th payments. In terms of broad brush approach, we do rely on Justice Giles in ADL and Frontline Development, which is at 8429, and that makes the point that any successful claimant party usually loses a few issues along the way. The issue on cost is who has been dominantly successful, and we say on a realistic assessment that is clearly SBM. And on the indemnity costs issue, we look at the absconding, the failure to comply with the freezing order, the failure to provide a document reduction statement. And on that, if I could just add a couple of references, there was an order made on the 2nd of September 2021, page 996. That was ignored. Further order, the 3rd of October 2021, that's page 175. That was ignored. Their failure to attend the trial essentially abandoned or collapsed the trial, so it had to proceed with no witnesses, no cross-examination. That in itself was contumelious in that we had sought time to recast our cross-examination, including Mr. Mehta. We needed 2 days to do various things, including that. And Mr. Mehta, if he had known that he had no intention of attending, could have saved considerable time and court time too, because the court had to reserve 2 weeks of time on the assumption there will be a trial with witnesses. So our time and costs were wasted. The court's time was wasted, and in those circumstances, we say that is clearly a case out of the norm that justifies indemnity costs. And so to finish, we say the court under Walker and Quayside may exercise afresh its discretion on costs, and we say we would urge the court to do that in awarding SBM its cost of the action on the indemnity basis. And Lord, I'm grateful for all of your indulgence.
Thank you very much, Mr. Reid. Yes, Mr. Pillay.
Good afternoon, Your Honours. Your Honours, Rule 17.43 of this court requires that full and specific details of any allegation of fraud, dishonesty and malice or illegality be pleaded. Where there is a gap, a point isn't addressed in the rules of the DIFC court, then by Rule 2.10, the Commercial Court Guide in England is used to fill gaps, and that makes clear at 1.3c, little 2, that where an inference of fraud or dishonesty is alleged, the facts on the basis of which the inference is alleged must be fully set out. Although there is...
RDC what? RDC, what was that? RDC?
So that it's RDC 17.43.
17.43, yes.
And
yes.
then under
CPR?
RDC, it's CPR.
210.
It's not CPR, it's the Commercial Court Guide.
It's in the Chancery Guide.
It's Commercial Court Guide, okay.
The requirement to plead particulars of fraud. No, it's part 17.
Can you unmute yourself? Do you want to put your mute on, Rupert?
I think
Mr. Reed,
the
your
read,
phone
we can hear you.
is on. Okay, yeah, sorry. Yeah, Mr. Pillay, sorry.
Okay, I'm going to start. So RDC 17.43,
Yes.
Chief Justice.
Okay.
Then under RDC 2.10, a gap is filled in by the English Commercial Court Guide, and the Commercial
Yes.
Court Guide reference is C 1.3, and then little c, and then little Roman 2.
Okay.
So that
Commercial Court Guide. Okay.
great. Yes. And that's what sets out what you have to put into your pleadings if you're pleading these serious allegations, as the court would expect. Now, there is a page limit, but it's very common that parties apply to the court for permission to go beyond a page limit if they need to provide proper particulars so that a defendant has notice of the points that they need to be made aware of, that they need to answer in relation to allegations like this. My experience is that commonly such permission is granted because the courts recognise how important that is. And in any event, we note in passing that the particulars of claim in this case were well short of the page limit. So presumably there were 6 pages here that could have been used but weren't used to deal with the particulars in relation to the claims that were advanced and then rejected by the judge. One of the things that we say is that one can't simply say, as Mr. Reed sought to today, that, well, the fraud was denied, so everything we alleged is in issue. That's not how it works. What happens is that the claimant must set out his case in detail, and then the respondent knows what he or she has to answer. Now, I'm sorry for going over this to labour it, but I think it would be helpful for the note, because the focus yesterday in Mr. Reed's submissions were a series of allegations about a lack of genuine documents. You were taken to pro forma invoices and to contracts. Those all relate to the allegation that there were documents that were forgeries. And the judge has considered that and rejected it. That's at paragraph 39 of his judgment. I'm not going to turn it up, but Your Honours have it, and I appreciate that you'll go back to that. But the 2 points that were made there is that the bank sought to argue that documents were not made with the involvement of Prime, but were forgeries, and they relied on the evidence of Mr. Sadder on that. And it was also alleged that there was no correlation between advances made by the bank to Prime and any specific cargoes of oil. And the judge said that there's no allegation of forgery in the particulars, nor is there any reference in the pleadings to the alleged mismatch between payments and specific cargoes of oil. So in other words, the judge concluded there is no pleading of any of the primary facts from which the inference of fraud in this respect is sought to be drawn. And the judge there had in mind plainly the requirements of pleading that I began with. Now, my learned friend didn't take you to any language in the contracts, in the pleading, in his particulars of claim, which made good the assertion that this is all pleaded. And we say it's inappropriate for this court to have been taken to all of that material in circumstances where it doesn't relate to a pleaded case. And the judge had expressly rejected the bank's attempt to rely on it at first instance. There's no reference to contracts or purchase orders that were not genuine in the pleading. And if a case was to be put on the basis that X or Y was forged, then that has to be pleaded. It's against principle for it to be otherwise. And, Your Honours, you can't simply say, well, it's in there, it's the vibe of my case. That's not how these things work. And you can't unpack a pleading of sham and say, well, in any event, underlying sham must be that I'm saying all of these documents are not genuine. Which documents? These things need to be identified. So, Your Honour, that we say deals with the attempts to rely on in the additional reasons and so on this material in relation to forged documents. And then today, a lot of time was spent arguing that Prime and Renish acted as a single entity. Now, that's, again, not pleaded. It was dealt with by the judge at his paragraph 37. Mr. Reid spoke about a lack of an arm's length dealings and adverse inferences to be drawn from the fact that somehow Renish had not explained why it was distinct. And the same point applies in relation to the banking arrangements and the timing of those. The judge looked at that. If you look in the judgment at paragraph 38, you'll see that the judge, in fact, dealt with the specific allegation that the point about this was all pleaded in paragraph 61, which is what Mr. Reid referred the court to. The judge said at paragraph 38, although there is a reference in paragraph 61 of the particulars of claim to accounts of NBK and an opportunity thereby given of moving money quickly and without close scrutiny, the allegation now sought to be made with its emphasis on the timing of the opening of the accounts goes well beyond what is pleaded. And what he said at 37 in relation to an allegation that Renish and Prime operated in effect as a single entity throughout the material time, and further evidence in relation to that. And in particular, the judge referred to identification of specific individuals who are said to be employees of Renish but acted for both Renish and Prime.
Yes, okay. I'll turn off the other one. Okay, thank you.
Chief Justice,
yeah, please continue.
Okay?
I'm so sorry. Something went wrong again, like what happened yesterday.
I'm sorry.
Yeah, where you, Mr. Pillay?
I was just saying that at paragraph 37 of the judgment.
Okay. Yes, continue, please.
Paragraph 37 of the judgment, Your Honours, is where the judge rejected all of these allegations about individuals, employees acting for both Renish and Prime, and the allegation that they were operating as a single entity, or as it's been put in the skeleton argument, hand in glove. The judge said, paragraph 37, in the final sentence, there is not even a hint of this in the bank's pleadings. So these are points that are actually not the subject of any findings in the judgment and actually were excluded because they're not properly pleaded. So they're not properly before the court below and they're not properly before this court. The judge then made no findings about alleged circularity of payments, which is something Mr. Reid pressed upon this court. There's simply no evidence finding in relation to that. Mr. Reid freely drew associations between Renish executives and third-party companies, but there's no finding about ownership or control of Astron and Novan. That's expressly the position that the judge says at paragraph 52 of his judgment. And it appeared that the bank's suggestion is that money was sent by Prime to those companies, but Renish has to explain why that's not fraudulent. I mean, one can plainly see the reversal of the burden entailed in that suggestion. And, Your Honours, I'm dealing shortly with these points simply because there is a short answer to it. It doesn't require going back into the detail and rejecting it because these are not matters that are properly before this court. And there's a further point which arises in relation to the additional reasons. And His Honour Justice French asked us about authority dealing with this. If you have the bundle N to hand, which I'm afraid has been updated, but there is a case in the Court of Appeal of England called Wolf and Trinity. Now, I have that at tab 6. And that begins at page 9165. Can I ask the court, please, to look at that? Now, while you're finding that, that was a case where the claimant alleged 4 causes of action and succeeded only on the first, being a claim for procurement of a breach of contract. And the first instance judge it was, I think, Sarah Cockrell QC, as she then was, dismissed claims of procuring conversion and conspiracy. Now, in response to the defendant's appeal, the claimant said in a respondent's notice that the deputy judge at first instance ought to have upheld the claim of procuring conversion and conspiracy. And I don't know if you've got the head note there. Do you have 9165? Yeah. You can see it. I'll take you from the holding. So halfway in the page where it says held in italics. The claimant, having succeeded on one of a number of claims, sought to argue in response to the defendant's appeal that the order of the court below ought to be upheld on the basis the court had been wrong to dismiss the unsuccessful claims. That was not merely seeking to defend the order for reasons differing to those relied upon the court below, but rather they were appealing against part of the order below, and so were required to file an appellant's notice and to obtain permission to appeal. Now let's go to the relevant section of discussion, which in fact is in the speech of Sir Timothy Lloyd, former Lord Justice of Appeal, at paragraphs 81 onwards. So that's page 9184, Your Honours, beginning at G, para 81 towards the foot of the page. And you see there, the judge set out the position that TUSA wanted, which was responding, which is one at first instance, wanted to argue that the judge was wrong to dismiss its claim in procuring conversion and conspiracy. It didn't challenge the dismissal of the claim in deceit. And so what was accepted was if you wanted to challenge the dismissal of the claim in deceit, permission would be required. And then at paragraph 82, you see that Mr. Knox for TUSA said that he could not have appealed against the dismissal of the conversion and conspiracy claims because he said that the order against which the party can appeal is that which has to be and can be enforced, not the reasons. And then in the next paragraph, Sir Timothy Lloyd said he cannot accept that submission. The order does not in terms record the dismissal of TUSA's other claims, but the substance is apparent from the terms of paragraph 2 of the order. If TUSA had wished to do so, it could have appealed with permission against the dismissal of its other claims against Mr. Wolfe. And then going on to paragraph 85 at the foot of the page, Mr. Knox was arguing that TUSA was just a respondent who seeks to contend that the order of the court below should be upheld for reasons other than those given by the court, and therefore had to serve a respondent's notice, but didn't require permission to appeal because it wasn't appealing against the order. But the judge said that at H, I regard the contention by a respondent that the judge was wrong to dismiss one or more distinct claims as something that requires and amounts to an appeal. And therefore, he reached his final conclusions at 89, which is the point of principle here that applies. If a claimant asserted two claims, of which one was successful and the other was dismissed, and the defendant appeals against the judgment on the first claim, then if the respondent wishes to argue the court below is wrong to dismiss its other claim and that the order should be upheld on that basis, that assertion amounts to an appeal against the order. It is not within the category of seeking to contend that the order of the court below should be upheld for reasons other than those given by the court. And so what we say is that that applies here, because the bank is actually seeking to rehabilitate its overall fraud claim through the guise of additional reasons. And we've seen that from SBM Skeleton at 87 and 88, where it suggested that had the judge taken into account submissions and evidence which he expressly excluded, he would have concluded that there was overall trade finance fraud and a fraud in relation to the fourth advance. Now, the bank has not sought to appeal the overall rejection of the trade finance fraud, but that really is what it wants to do. And the bank has not appealed the judge's exclusion of inadmissible evidence and unpleaded arguments. And it's sought to get that in, to lever that in before your lordships, before your honours, on the basis of, well, I've put in a respondent's notice and I've got a cross appeal. But that material was not before the court of first instance, and it should not be allowed in now, because the conclusions that the bank wants overturned, your honours, is that the judge wrongly rejected unpleaded submissions, that the judge wrongly failed to take into account evidence before it. And that followed from the substance of the judge's order below. So if the bank wanted to challenge that, then it needed to appeal the order, and it needed to challenge those determinations on an appeal. There is no such appeal, Your Honours, and that means that the point ends there for them. So that's another reason why you can't take it into account, because they haven't appealed it. Quite apart from where I started, which is, well, it wasn't before the court below, and you can't look at it. They haven't even appealed it. And it would obviously cause serious practical issues, because...
Sorry, can you just define with precision the "it" which they can't appeal?
That they haven't appealed is the judge's conclusion that the arguments that were raised, that were referred to in the judgment at 37, 38 and 39 be excluded. And the evidence,
of the pleading issue.
Yes,
yeah.
The pleading issue and the decision on inadmissible evidence. Those are the two heads which they had to appeal, because that goes beyond defending the existing claim. What they want actually is to rehabilitate arguments. So by parity of reasoning with Sir Timothy Lloyd in the Trinity case, Your Honour, that's where it comes in, because you're trying to do more than just defend what's already there. You're trying to, and you heard it front on today, Your Honour. It was a full attack on the judge's findings, conclusions that pleadings should be, that the judge is pleading the conclusion from the judge that these matters were not pleaded, and the conclusion from the judge that he should not consider that evidence. The bank attacks all of that. That goes beyond merely defending a claim. So they didn't appeal it, and that's that. It's not open to them to run it now.
What would they have appealed? Would it be the interlocutory order?
Well, it wasn't an interlocutory order. They would
order. No, it wasn't.
Right. I put it into the, I think we summarised it in the skeleton, but essentially what they would be appealing is the order saying the judge was wrong only to find that there was a fraud in relation to the 5th and 6th implied representations. It should have found that there was an overall fraud, and it should have found that the arguments that I ran, which it rejected at 37, 38 and 39, were admissible because they were pleaded, and it should have found that the evidence in support of all of those points was admissible, and it did not need to separately be adduced, and I was entitled to rely on it. It's not an interlocutory order, but it's basically saying
because it was a way the judge treated the evidence in the course of his reasoning. I guess he said, he didn't say during the course of the hearing, as I understand it, you can't rely upon that. I mean, he did. He taxed Mr. Reid, I think.
He did. He did
during the course of the evidence. But it's all right.
So what he's done there is make two findings that are in support of or subsidiary to his order. It's the analogue, and that's why I say by parity of reasoning, Your Honours. It's the analogue to saying I'm rejecting your claim in deceit. I'm rejecting your claim for procuring a conversion. I'm rejecting your allegations of fraud on the facility agreement fraud. I'm rejecting 3 of your implied payment rep frauds. And in the course of doing that, I'm rejecting your reliance on an unpleaded case and evidence that hasn't been adduced and isn't before me. Your Honour, that's the authority that we were able to find in relation to this point. But we think it covers the point directly, but in any event that Your Honour can see the analytical pathway through in relation to this. Now, there are a couple of other sort of points in the general way in which the matter was characterised yesterday that it's worth raising. Mr. Mehta has explained his position in relation to the payments that concern the judge. Prime has dropped out of the picture, but it was centrally involved in these matters, and we say that there's no doubt that there was a significant history of trading between them. And what the bank has sought to portray as fraud by Mr. Mehta and RENISH is understood from the appellant's side as being a fraud carried out by Prime, which received the monies from the bank and no oil was delivered in respect of those last two advances. But speaking colloquially again, Your Honours, the settlement with Prime has, in effect, on this side of the curtain, because we don't know what the basis of that settlement was, has left Mr. Mehta and RENISH holding the baby. But the absence of findings against Prime does not change the appellant's pleaded case that it was Prime that perpetrated the fraud. And Mr. Reid yesterday felt he'd made a great forensic point that RENISH was not even pursuing Prime. Now, he corrected that shortly before the end of submissions, but put shortly, and it's a matter of record, that RENISH has issued claims against Prime in the Sharjah courts. It won in the Court of Appeal. The matter then went to the Court of Cassation, which has then remitted the matter to the Court of Appeal in Sharjah. And our understanding is that the court in Sharjah has decided to appoint a further expert, and judgment is delayed on that. But that I hope puts to bed that suggestion.
Wait a minute.
Yes.
Mr. Pillay, the suit against RENISH by Mehta in the Sharjah court, you didn't tell me who was successful. Was Mehta successful?
Yes, so RENISH succeeded in the Court of Appeal
against
Prime, but it went to the Court of Cassation, and the Court of Cassation has remitted it, and a new expert has been appointed in the Court of Appeal in Sharjah, Your Honour.
For what? For what was the cause of action against Prime?
My understanding is that it's a fraud claim, but I can give you the
committed by Prime.
That's my understanding, and I'll take instructions. There is the bundle reference to evidence given by Mr. Mehta on that as at June is F/45/2138. This, I think, was relevant in the context of the contempt proceedings which took place earlier this year. And I think that the bank is alive to all of this because the bank itself has pointed out that the Court of Cassation had remitted the matter back to the Court of Appeal. So I don't think there's any dispute between the parties.
Is there page reference, a page number there? No,
for that point, I don't have that.
Okay, but you said it was in Mehta's statement.
Yes, that is F/45/2138.
138.
At the end of the day, that really doesn't bear upon this appeal, does it?
No.
As I say, this is part of correcting a record.
That's all right. Yeah.
That's all, Your Honour. I don't. And Your Honour, just to finish on these sort of colour points, as it were, having moved from the precision of the pleading points, what the bank had called tactical should probably be viewed from the appellant's side as action to be taken to clear the appellant's names. That applies to the pursuit of the present appeal, the application to purge contempt, and the pursuit of RENISH. And I think my learned friend said yesterday, very conveniently, Mr. Mehta popped up only after there was a treaty between the UAE and India which allowed for mutual enforcement of judgments. Well, that, of course, doesn't affect the fact in relation to this fraud claim because the bank already has an enforceable judgment on the contract. So if there's a treaty, then that presumably is in the bank's favour. Your Honour, I'm going to move on to the suggestion that there is such a thing as a trade finance fraud, which is how Mr. Reid opened yesterday. The bank made a series of submissions that were entirely without an evidential foundation as to the nature of trade finance claims. Now, of course, this court doesn't accept evidence from the bench.
I'm just wondering, do we have to get into that kind of interesting generic discussion? In the end, that's a genus which covers a whole array of possible sets of transactions. We've seen them in this country, in Australia, and in other places. But our focus must really be on the facts of this case, however it be labelled.
Your Honour, I agree. The existence of implied representations is highly fact-specific. They don't arise, just without more, just in this commercial context. Can I make a follow-on point, though, which is relevant to this particular case, is that generally there is a contract, and here there is a contract. And as I sought to make clear in my submissions, the contractual promises cover the commercial bargain and what was negotiated. And as part of the shift in the way the bank was focusing yesterday, Mr. Reid spent a lot of time talking about an implied representation as to the purpose for which monies were to be used. Well, we say that's not pleaded, but in any event, given the contract, there is no reason why that would be implied here, because as is common, there is a purpose clause, a clause 2.5. And there's no claim for breach of that. But if that's the claim that is now to be run, of course, too late, but there might conceivably be a breach of a contract if monies were put to a purpose differently to that provided for. But that's the highest it gets. That's not a claim in fraud. And all the appellants did here was make a utilisation request. And we say that does not found a fraud claim. Moving on then to the legal test on the inference of dishonesty. I'm not going to repeat the points, of course. The English authorities remain relevant and applicable, with the focus being on what principles are applied to infer dishonesty at trial. It's right, though, that those principles be taken on in the law, in the DIFC, just as it is in the English courts, and also in the nuances reflected in the Australian approach that is Honour Justice French referred to. They're all of a piece. You look at the seriousness of what's being alleged, the inherent unlikelihood, I think was the language Your Honour quoted, the gravity of the consequences, and all of that needs to be considered in that open textured analysis of whether the balance of probabilities that an inference of fraud is made out. I don't think there's much point in dancing on the head of a pin about it, and it wouldn't be a surprise that the law in the DIFC reflects that sort of depth of analysis, because of course one isn't always looking in the shadows and behind doors for fraud, and that's not how commercial operations work. Parties expect good faith dealings on the face of it, and so, Your Honour, I think I can stop simply just by saying that the quotation from Sir Geoffrey Voss in the Bank of Petersburg case makes clear by reference to Lady Hale's judgment in Re B that inherent improbabilities are to be considered as part of that exercise, as does motive. But it's not motive as applied to all of mankind. It needs to be motive that's relevant to the particular granularity here. And here, disincentive, the destruction of Mr. Mehta and RENISH's business and life in Dubai are all matters to be taken into account, as well as previous unblemished records and so on and so forth. I'm now going to move on to talking about reliance on the permission to appeal judgments. I'll make the point shortly. The court and the parties are entitled to see and expect to see all relevant reasoning within the four corners of a judgment. And a judge usually gets one chance to reach a conclusion with reasons and has the time and space to produce a judgment, and that happened here. What happens quite rarely is that after handing down a judgment, or a draft judgment as happens in the UK, one or other party may suggest that other reasons or further reasons are required, but that usually happens promptly.
Does that happen with draft judgments in the UK, or is the draft given to the parties just for the purpose of correcting factual errors and things?
Yes, the scope of what you're meant to do is just say, here's your spelling error, or here's a couple of references. But if there is something that hasn't been dealt with, and you can properly say that, and as counsel can properly say that, then that's an occasion to do it. But it's not.
It arose in the case of the Prince Charles diaries, I think, didn't it? It may
well have.
There were drafts sent, and the question is whether the Prince should get them.
Well, if he was a client, then I think he would be entitled to see them. But yes, there's a different point about who's entitled to see an embargo judgment. But, Your Honour, the point is here that process of giving additional reasons, and including giving reasons in a permission to appeal judgment, is not for the purpose of correcting errors on conclusions that have already been made. And that's why you very rarely see appellate decisions poring over permission to appeal judgments, because the judgment stands as the decision. And the cases that the bank relied upon were about judges who had failed to deal with specific points and therefore clarified their position. What you're dealing with here...
There's a general issue of perception. I think I put to Mr. Reid that one looks at the function that the judge is carrying out in dealing with the applications for permission to appeal, and that requires determination of whether there's a reasonable prospect of success or compelling grounds. There is a what I might call a cosmetic problem if the judge takes the occasion to elaborate upon his or her reason in light of the grounds of appeal. And that's why I think one should approach that process with some caution.
Well, so
it's not suggesting it's done in this case, but there's just a general question of principle about the restraint that a trial judge dealing with an application for permission to appeal should exercise when
giving reasons.
Determining.
Yes. Your Honour, well, that was going to be my third point, which is that an appellate court will be wary of a second judgment purporting to provide new reasoning, particularly by reference to a different legal test to the one that the judge had cited and applied in the judgment. And the risk in these circumstances, particularly where a large period of time has passed, is that the second judgment becomes a risk, an exercise in ex post facto rationalisation. And that was a risk which Lord Justice Ricks identified in the aerospace publishing case that we have cited. If you have bundle N to hand or on a screen, that was a case where, in the end, there wasn't a matter wasn't referred back to the judge below. But if you look at 9163 in tab 5 in bundle N, paragraph 13, and I think these may be principles relevant to Your Honours if you are going to make comment on this, but what the Lord Justice Ricks accepted there was Mr. Rainey QC's submissions, saying, it seems to me that Mr. Rainey is right to submit that the likely result is either a nil return or a danger of ex post facto rationalisation. Although it may be that this court could see its way to deal with such a situation, nevertheless, there is no doubt that the dangers of such ex post facto rationalisation can render unfairness and injustice to the parties. There is also the danger that the argument on appeal is simply increased in its spread by any such further reasons as might come forward in such a situation. And then the judge explains that they were not going to go ahead because he's picking up on the final sentence. It seems to me that the greater danger is that of upsetting the fairness and integrity of the judicial process upon appeal.
Well, the focus must be upon, as I said before, on the function that the judge is undertaking. And in determining whether the appeal has reasonable prospects, the judge might well refer to what he found, refer to the reasons that he gave.
Yes.
But I think, and say, well, those reasons involve findings of fact, which are unlikely to be, et cetera, et cetera. But the area of difficulty is where the judge said, what I meant to say was, I'm not saying that happened in this case, but one can imagine exposition which goes beyond the function of determining whether on the judgment as given there are reasonable prospects of success.
Yes, Your Honour. It is fundamentally a different test. And, Your Honour, of course, judges are human, and that it may well be a natural impulse to take that extra step. Your Honour, we do say that one of the dangers of the ex post facto rationalisation here, 8 months afterwards, was that the trial judge's reasoning goes beyond the initial judgment, and findings and analysis were there. And we say that that is what has happened here. We say that this is a situation where, though he's applying the permission standard, the judge sought to contort findings to fit a different test that he did not have in mind or at trial or when writing the judgment. And we say that he does not engage with how his proposed approach on law was right in light of the legal principles set out. What you see actually happening is saying, well, even if that was the test, then I was right on that. And at places, the drafting reads a bit like legal argument, where he refers to conclusions being irresistible and that it was surely obvious to the appellants that they were making implied representations. Those are examples from paragraph 27. There is more assertion than analysis. Now, I don't think you need to go into any of this or criticism and a judgment, Your Honours, but we are giving you these submissions because we are here. It's right to do that for this purpose. I've given you the law, which I think may assist in the approach to that. So, Your Honour, that's all I wanted to say about the limited weight to be given to the pre-trial, the permission to appeal application. I've just got some short points then to make on the fair presentation, and I will be done by the usual break time. Your Honours, on this, there was significant criticisms of Mr. Mehta's conduct prior to the trial. And what happened is a matter of record, but equally, if you read the transcript for day one, where Mr. Mehta came to court and then was told that Prime had settled and so on and so forth, we think a fairer approach is appropriate. But it would be wrong to suggest that conduct somehow meant that Mr. Mehta was not entitled to, and that the court was entitled to overlook the obligation, the duty to make a fair presentation. You don't get penalised. I mean, the case of CMOC is an example where defendants were never identified and never engaged, but still the obligation and the duty was notified and complied with. We say, I just want to pick up on a couple of points. I mean, it was suggested that Mr. Mehta spoke English as a third language. Now, understanding that in context, it would be surprising for many as a litigated person to be able to run a legal case in a third language, a real gift if that were possible, but vanishingly rare. There was an explanation that, well, look at this multinational business across the Central Asia, the Middle East and East Asia. Again, that doesn't necessarily mean you can be fluent in legal English. And Mr. Mehta had explained all of this to the court in written evidence, including at the permission to appeal stage, and also the initial hearing on day one. The bank also sought to diminish the nature of the task set for Mr. Mehta by the judge on the adjournment. Now, that included asking Mr. Mehta to look at Prime's evidence and pick out what he wanted to rely on. Now, he also then had to deal with the skeleton argument that was provided the night before trial started. And it's unrealistic for a layperson whose first language is not English to do those exercises on those sorts of timeframes. It might be relatively easy for a lawyer to identify factual evidence of relevance from a 73-page witness statement, but it's not even easy for a layman to get through a statement of that length in one day, even if they're businessmen and have commercial experience. The court will probably know that commercial people have the least patience. Anecdotally, I say this, with legal presentations of evidence. And the last point I want to make is about the context in which we said that the court should have been alive to and should have been assisted with references to evidence from Prime. Now, I'm not going to repeat paragraph 24. You have what the judge said about that. Can we just look at this one reference, which is at G, tab 1, 2163. It's 2163, Your Honour. 2163.
Okay.
And this is a discussion between Mr. Reed and the judge. And if you look at, I mean, you can look at 2162, sorry, Your Honour. If we begin at, it's page 22 internal of the transcript. Do you see that? At the top of the page, there's a sentence that begins, clearly there is an issue.
Yeah.
Now, if you scroll up to the previous page, you'll see that the context is talking about references in Mr. Sadr's evidence. And Mr. Reed says, clearly there's an issue about how much force can be, how much weight can be attributed in circumstances where the relevant witness hasn't been cross-examined. And Justice Glennie says, well, and there would be bits of those statements Mr. Mehta might want to rely on, and bits that he can do as he thinks appropriate with those statements. Is that your understanding? And Mr. Reed said yes. And then Justice Glennie goes on to say, I was going to ask, was there is a certain amount, or quite a considerable amount, in prime skeleton argument, which might be said to assist Mr. Mehta's case. Presumably that would, as a document, will remain to refer to, that he can refer to bits of as he thinks helpful. And then Mr. Reed says he'd need to adopt that by submission, wouldn't he? And Justice Glennie says yes, but it's not necessary or nothing. And the discussion goes on. And the point there is they're discussing, well, what's going to stay in the trial bundle and what would need to be adopted at trial for him to run those arguments. Now, Mr. Mehta didn't attend trial. We know that. But what I say underpins all of this is as follows, is that the judge knew that Renish and Prime were at odds. And as I've said, it's the appellant's case that Prime perpetrated the fraud. And the judge knew that Prime was no longer going to be there. So he was then wondering, well, what's going to happen to these points that actually favour the appellants and therefore go against the bank? And how will that come before me? And he was concerned to work out how that would be. And the conclusion was, well, it'll be adopted either as submission or it would have to be adduced as evidence. That stands to reflect what was understood by the parties. But it means, therefore, that the fact that there were criticisms by the appellants of Mr. Sadr's evidence on certain points did not exclude its relevance where it contradicted the bank's case and assisted the appellant's case. That was something the judge was aware of, and that the bank had accepted was something that might be argued by Mr. Mehta. That's what had to be brought before the judge, and it was not. Now, Your Honours, those are my reply submissions. Unless I can assist the court further, that concludes the appellant's submissions on this appeal. I'm grateful.
Thank you.
My Lord, if I could go back just on one or 2 points very, very briefly, and they are essentially relating to the new cases. The Trinity and Wolf decision to which my learned friend referred, and if I could just turn that up, that is, I can't remember the page reference for that, but if I could, you remember that's where there are different causes of action. And my learned friend took you to paragraph 83 in that judgment, where Sir Timothy Lloyd said, the order does not in terms record the dismissal of Tutor's other claims against Mr. Wolf under the other causes of action. So we say that's entirely different, because what one has there is an order which doesn't in terms dismiss the various causes of action, but impliedly the judge below, the deputy judge, had dismissed the claims under all the causes of action. So we say in those circumstances, clearly a respondent's notice wasn't enough in order to seek to revisit the judge's findings on specific causes of action. As your lordship adverted you here, we're dealing with something different, which is that essentially the judge decided that he wasn't going to look at, he was going to exclude evidence and exclude arguments on the basis that they didn't come within the pleading. I don't think I'm going to say more about that. I think the court's had my submissions on the pleading point, so I'm not going to develop that further. Just in terms of the cases on supplemental judgments on the permission to appeal applications, your lordships have the decision that we added to the bundle, which is the Millennium Village case. If I could just very quickly look at that again. And I should say, in respect of that, the judge, Lord Justice Jackson, in that case, that wasn't a case of, as in our case, clarification and explaining. That was actually a case of amplification. And so it said that the judge hadn't given particular reasons. And when one looks then, just to give you, sorry, to give you the reference, that's at page 9118. And if one goes on in the judgment to paragraph 40, internal pagination 3523, one sees the paragraph 40. In the course of his judgments, the judge made the following findings. And then little Roman 1, little Roman 2, little Roman 3 over page. So see the main judgment and see the supplemental judgment. And then at various points, for example, little Roman 13, towards the bottom of that page, alternatively, HSE is entitled to recover an equivalent sum as damages for breach of the subcontract. See the supplemental judgment. So in terms of dealing with an appeal that matters have not been dealt with by the judge, Lord Justice Jackson is prepared to refer to exclusively to paragraphs of the supplemental judgment where the reasoning can be found. And of course, as your lordship identified yesterday, a critical paragraph for these purposes for us is paragraph 18, which is an important clarification in terms of the bona fide trading and the finding of the judge that there was no bona fide trading.
I'm sorry, the reference to a supplemental judgment.
Yes, well, that takes on back to paragraph 17. So the judge in that case, in refusing permission to appeal, gave a supplemental judgment, almost exactly as in our case. And that's paragraph 7, internal pagination 9121.
Sorry, let me just catch it. Would you? Yes, 7.
So this is Lord Justice Jackson. When asking the judge to grant permission to appeal, Robson produced its draft grounds of appeal and skeleton argument. In his judgment refusing permission, the judge amplified. So he wasn't merely clarifying his way, he in fact amplified the reasons for his original decision. I've wondered whether it's legitimate to take into account the second judgment. My conclusion is that it is appropriate. And then at the bottom of that paragraph, he refers to he then defines the main judgment and the supplemental judgment.
Well, I think that language is rather suggestive, isn't it? And it does tell you that what the judge is doing in giving a supplemental judgment may be going beyond what the judge is required to do in determining whether permission to appeal should be granted. I'm not sure whether, I presume the criteria for the grant of permission to appeal in that case are analogous to the criteria we're dealing with here.
Yes, my lord. Yeah. And I concur with my learned friend's comments. Obviously, it isn't something that one would wish for, and obviously the Court of Appeal should be wary to some extent of where there is some supplemental reasoning. But where the court has clarified, explained, and on this case even amplified its reasoning, there's an artificiality about an appeal court simply saying, well, we can't possibly look at that. And in an extreme case, the appeal court would have to say, well, let's remit. If it was an issue of fact that required witness evidence to be examined, that would have to remit, and that would be would make no sense in circumstances where the judge below, as indeed in the Greater Manchester, the Roche against Chief Constable Greater Manchester, the judge had in fact in his supplemental judgment found that there was no reckless assault as an arrestable offence, and therefore to remit that issue back to the judge would, as the court made clear, be entirely artificial and have no point. So in those circumstances, my lord, we say that the PTA judgment should be considered. In terms of draft judgment, I hear what my learned friend says, but the reality in DIC terms is that draft judgments are not circulated. So one doesn't have that opportunity to improve the main judgment. So arguably a fortiori, the supplemental judgment is important in circumstances where the parties haven't had an initial opportunity, as my learned friend rightly suggested, it sometimes happens, to suggest to the judge by way of comment on the draft judgment that he may want to add to his reasoning or add some explanation to his reasoning.
What do you think of circulating draft judgment, Mr. Reid? What do you think? Should it be in England? I'm told
it involves a certain amount of self-restraint on the part of advocates not to weigh in. So I can see why
a high-risk exercise.
It's a high-risk exercise, but on the whole, in this jurisdiction, England and Wales, counsel are restrained in terms of giving typos, obvious areas of fact which would be beyond doubt. But the other obvious issue is confidentiality, and there's been a certain amount of debate in this jurisdiction about the difficulties with price-sensitive information being disclosed by way of release of draft judgments. But on the whole, it works in this jurisdiction.
I did once when I was the Chief Justice, but there was no dispute of facts. It was just law all through. So I circulated to get the parties to comment on whether I got the facts correct or not.
Yes.
And nobody complained, fortunately. Nobody complained.
Well, the other distinction is that in England and Wales, one often now has judgments that are hundreds of pages. So to expect the judge to proofread without the relevant staff to proofread several hundred pages is a high demand, whereas the parties have also got large legal teams.
I agree with you. I think judgments are getting longer and more detailed. It's very tiring for me. You know, when English is, well, I can understand English, but I take longer to read than you all.
Yes, agreed.
Yeah. So is that all, Mr. Reid?
That's all from the respondents board. Yes, thank you.
Okay, I think it's a lot of us to chew and to consider, and I think I can safely say that it's going to take some time before we can come up with a judgment. So please be patient with us, Mr. Pillay, as well as Mr. Reid. And thank you very much for the very, I find it very, very interesting, not very informative, I get all the information, the facts of the case, a lot of things to read, not only going through the judgment, maybe the notes of evidence, and more so all the authorities. But thank you very much to you all for perhaps making our life a bit easier. So judges, can you stay on? Can we go to the judges link and sort of have a short discussion? Yep. Okay. So thank you very much. We'll come back with our judgment. Thank you very much.
Hello.